So does the person getting a reversal and a remand, does that impact awards of attorney's fees and costs?
Yes, we discussed this a little bit ahead of time, and Judge Marsh, you weren't in on the round robin. Look, attorney's fees for appeals are a very different thing than attorney's fees in general civil litigation or even family court litigation at the district court level. At the district court level, often fees are assessed at the end of the case. In other words, who won, who lost, who was the prevailing party, and therefore who should get fees. It's turned on its head for appeals. The only way really in the real world of getting an order of fees in an appeal is to get them preliminarily before the appeal is even filed, or right after it's filed, before it's litigated, by a preliminary award of fees called pendente lite. Here's the setup. If you've gone to court and Judge Moss has made a decision and said for whatever reason, I won and Emily lost, and therefore that's the way it is. And Emily says, oh yeah, well, I'm going to appeal. And she goes up. I can apply as the party who prevailed at the district court level back to Judge Moss for a preliminary award of attorney's fees to defend the judicial order on appeal. It's a very narrow opportunity under a case called Griffith, but it gives you the opportunity, especially if you represent the poor person and the party on the other side is the wealthier party, to get a preliminary award giving you sufficient resources to defend the order you've already got. I hope that makes sense, but it's almost impossible to get awarded attorney's fees on appeal. I've been doing this for 40 years. I've been doing appeals since the 80s, and it's never happened. No matter how egregious the appeal was, I have never been handed attorney's fees for defending a case at the Supreme Court level. And the district court is generally prohibited from awarding attorney's fees upon remand for the time and money that you spent on appeal. So if you're going to get an attorney's fee award, you should do it if you were the prevailing party at the district court right at the time the appeal is filed with the pendente lite application.
That was going to be a question of mine, is whether or not after the remand you could get those fees, but nope, the answer is no. That's good to know. Generally,
no. There's exceptions for everything. We're talking law here, but the short version is no.
There's always an exception.
I think there are some judges, I'm not going to name names, but I think there's some trend with judges where they say, okay, I've made my custody decision, and you know that it's going to be appealed one way or the other, right? And so the judge says attorney's fees are deferred or separated out until the appeal is final. And I want to get the attorney's take on that. I think attorneys really want the decision, which is what I normally did. I said, submit it. You want a complete decision, submit your attorney's briefs. I will include that or add that as a supplemental order, like a decision regarding attorney's fees and costs, and certify that as soon as after my big trial decision was written and filed. And then I'll do a separate, because what I do is I do the decision, and then because the parties don't know who's the quote prevailing party in the trial. Once they know, then they submit for their memorandum of fees and costs. And then I usually turn it around. I used to turn around like a week or two and then make that so that you have two final orders, and then they can go ahead and proceed with the appeal if you know that definitely one party is going to appeal it no matter what. So, but there are judges, I think some of them used to just say, well, I'm just going to defer on attorney's fees, separate it out because I think this is going to be appealed, and we'll, I don't want to have to rule on it until the appeal is like final, or resolved and comes back to me. And so I think attorneys didn't like that. And so the trend for me was to make sure I did the final trial decision. They don't know who technically prevailed. Once they kind of know, then they submit their memorandum of fees and costs, and then that is separated out in order, and then the case is closed down, and then they can go proceed with their appeal. So kind of unusual how that would happen after trials.
Emily, have you experienced that either way, or I guess with this sort of resolution?
Yeah, it is really nice to have those attorney's fees decisions very soon after the main order, so that you can include it in the same appeal or amend your notice of appeal to appeal the fees award too. Because if it's deferred till after the appeal, you then might have to appeal again late. It creates such a huge can of worms if you don't get it all at once. So it's definitely best to have it all right together at the same time. just to make things more streamlined.